The next case is People versus Theodore Paul Wafer. Please proceed.
Good afternoon, Your Honors. May it please the Court, Jacqueline McCann on behalf of Theodore Wafer. I have my colleague Angeles Meneses at council table with me. I intend to save 2 minutes of time for rebuttal, Your Honor, but I understand it's my responsibility to manage that.
That's fine.
We are here today regarding the statute MCL 780.951. That statute uses the very broad language in the process of breaking and entering. That language is broader than that used in one of the later phrases, which is committing home invasion. That language, I would argue, is broader than attempt, as that concept is known as in criminal law. And as I would point out, the legislature is very familiar with that term, having set up the offense statute and using it in all kinds of statutes like the Habitual Offender Act, the felony murder statute. In the process of generally means that to have started something and still be engaged in it by dictionary definition. That general broad language may, for lack of a better word, scare or worry some people about what that might lead to. But the use of that language was a policy decision made by the legislature, and this court must give effect to the plain language of the statute. That policy decision, enacting that statute, is a substantive law, and so I want to point out in response to the prosecutor's supplemental brief raising the MRE 301 and 302, I believe, and the bursting bubble concept. First of all, MRE 301 does not apply to criminal cases by its very own terms. 302 applies to criminal cases, but it talks about presumptions against the defendant. So they are not in direct conflict with this statute. But even if they were, I would ask this court to look to People versus Watkins, 491 Mich 450, where this court examined a statute the legislature passed dealing with other bad acts evidence in relation to criminal sexual conduct crimes against children, and found that it was in conflict with MRE 404B, but that it was substantive. It did not purely deal with procedure, so it was not infringing on this court's prerogatives under separation of powers. And so this court gave effect to it with the limited exception that due process still required this court to direct the lower courts to apply 403. So again,
is it your view, counsel, that the Ms. McBride in this case dislodged the screen that lay outside the door and pushed it against the front door?
There is evidence that in her pounding on the door and perhaps kicking the door as the sole of her boot was also damaged, that yes, she dislodged that, and there's a marking of the screen door imprint on the main door. So there's certainly evidence consistent with the defense's theory that she was in the process of breaking and entering.
If that's true, why is that merely, in your words, in the process of breaking through as opposed to an actual breaking and entering?
I should say, Your Honor, that it's at least in the process of breaking and entering. You are correct that
why am I correct?
Could be considered
What's your basis?
A breaking in itself.
What is your basis for saying I'm correct?
There is a case
I don't know
law.
that I made an assertion. I was asking a question. But what is your basis for saying that I'm correct, that it might have been a completed breaking?
Well, a completed breaking requires entry, Your Honor. But there is some case law, I believe, cited in my brief, some older case law, such as that even putting a knife through the sash opening of the window is a completed entry. So going through that first barrier of the screen door, or at least the screen insert of the door itself was not opened. But going through that barrier of the house, the screen door being dislodged, arguably could be considered a breaking, but it is at least in the process of breaking and entering.
I can't recall. Did you call to the court's attention the case of People versus Nolan going back to 1871 for that proposition?
It is, I believe, a very old case, but I don't recall if it was that particular one, Your Honor.
Okay. Please go on.
We're asking the court to enact, or not enact, but to keep the rule that it has for any time a defendant asks for an instruction on a defense, which is that when there is some evidence to support that defense, that the jury must be instructed on it. This is a jury question. And there is a jury instruction on this that this court has approved. We now, the model instructions are now to be given unless there's some extra reason that they shouldn't be.
Well, in light of the fact here that defendant was found guilty beyond a reasonable doubt, notwithstanding his assertion of self-defense, why do you think the failure to give that instruction was reversible error?
Because, Your Honor, if you look at the general self-defense instruction, which I believe is at 7.15, and when it talks about the jury should consider the circumstances as they appeared to the defendant at the time, it tells the jury to look at things like the size difference between the parties, whether the intruder, or the person that self-defense is allegedly being exercised against, whether they're armed. It tells the jury to look at all these factors particular to the defendant and the complainant. If you look instead at the statute for the rebuttable presumption and its jury instruction, it specifically says that the homeowner is allowed to presume that the person trying to enter their home intends great harm or death.
Okay,
so even if you don't see them.
Please, let me ask a question. You were deprived of that presumption, but what harm did it do?
It is a thumb on the scale that the legislature intended as extra protection. Remember, this is the statute is our version of stand your ground, was intended to expand the common law defense. So it did not, he did not get that extra protection, that extra layer that would have told them that even though she was a 19-year-old girl unarmed, and the prosecutor argued this repeatedly in closing argument, that even though she was unarmed and a 19-year-old girl, he was, under the law, allowed, since he didn't see her, didn't know that, he was allowed to assume that someone was trying to come in to kill him.
I'm trying to understand how to operationalize it, the instruction. I'm assuming it should have been given, just let's assume that, and I want to try and understand how it would work and what it would do for the defendant. The jury instruction is written, gives the two predicate pieces if there's a breaking and if you find a breaking and entering and that the defendant honestly and reasonably believed that the victim was engaged in that, you must presume that the defendant had an honest and reasonable belief that imminent death would occur, which I guess helps him in the self-defense. Then I'm turning to the self-defense instruction. That helps him with the honest and reasonable belief. But since the jury, as the Chief Justice asked, since the jury found him guilty beyond a reasonable doubt, don't we have to assume that the jury found that the prosecutor already disproved that reasonable doubt beyond a reasonable, disproved that he had that honest and reasonable belief beyond a reasonable doubt? Like, I'm trying to figure out what exact work this jury instruction would have done for him. And how it would have, how would it, if the jury got that instruction, they went back to the jury room, how would it have gone differently, since they clearly had to find that the prosecution disproved beyond a reasonable doubt that he had that honest and reasonable belief? It
changes the framework of the argument and the deliberation. So when the prosecutor's making those arguments, look, she's inebriated, she's unarmed, she's a young girl, she can't hurt him, he had no reasonable and honest belief that she could inflict harm on him.
The prosecutor can't argue that?
Yes, but with the presumption, the jurors would say, well, but the law says that he's allowed to, he didn't see her, they didn't talk to each other, and he didn't see her, he saw the shadow come in front of the door. He's allowed to assume that the person trying to break into the house is capable of harming him and killing him. So the prosecutor should have to show more in the sense that had he looked out the window and seen that it was a Girl Scout or Miss McBride unarmed, that would be, that could get beyond the presumption. I was trying to think of examples of what can get beyond the presumption if the homeowner is lying in wait. I know we've had some cases recently in the national news where someone's tired of their house being broken into. And so they make it look like the house is, like they're gone. They turn off the lights and hope the people come back. And I think the one gentleman hid in his basement with a rifle and waited till the juveniles came downstairs, and he shot them on the stairs as they were coming down. So if you create the situation to bring the people in, or if you have one of those spring-loaded guns that goes off when the door opens, that would overcome the presumption. But I don't believe it was overcome.
But proof beyond a reasonable doubt that he didn't have that reasonably doesn't overcome the presumption?
They looked at it in the context of as if he had seen her, as if he knew that she was unarmed, as if he knew that she was 19, as if he knew it was a girl, as if he knew she was intoxicated, as if he knew she had a closed head injury. Or at least that's what the regular instruction tells them to do and what the prosecutor told them to do. The rebuttable presumption says, no, hold on a second. He's allowed to presume that the person coming in is dangerous, and he's allowed to act before he sees them and makes those determinations based on their appearance.
Wait, but counsel, now I'm confused, because if I'm the prosecutor then, once that instruction is given, how do I just automatically lose? If the defendant gets the instruction, the prosecution can't overcome the instruction in any way?
It would depend on the evidence that had been introduced at trial, Your Honor. If there had been evidence, as I said, of somebody lying in wait, looking out or just happened to be looking out the window and had seen that it was not somebody armed wearing a mask with a pry bar, but it was somebody,
but
who
unless
looked
it's
to be
a
like they
lying
were
in wait
bleeding.
kind of circumstance, if it's a breaking and entering, the only thing I could really prove is a sort of lying in wait. Otherwise, that defendant automatically wins.
As I said, the legislature intended that the homeowner have very broad protection when somebody's trying to come into their house. They don't want the homeowner to have to be making a split decision, worrying about whether or not later I'm going to find out I was wrong, honestly and reasonably wrong perhaps, but later I'm going to find out I was wrong and they're going to second guess everything I did. The legislature says, no, at least we want a rebuttable presumption that says you're allowed to make those assumptions unless they can show there was some reason you shouldn't have assumed that this person was coming in was armed and dangerous.
Whatever impact the absence of that instruction had, can't an argument be made, and it hasn't thus far been made, that an even greater impact occurred when the trial court instructed the jury, quite wrongly, that it could consider retreat as a factor? It then went on confusingly to explain to the jury that a person is never required to retreat if attacked in his own home. Now, either those are inconsistent instructions, or if they're not, attacked in his home seems to suggest it has to be within the four corners of the home and can't encompass the porch and the curtilage area as well.
This is the Richardson problem,
Can I
Your
please
Honor.
finish my question for a
Sorry.
second? Okay. Can you tell me what the impact of that was?
It's the Richardson problem. Your Honor dissented in Richardson. It was that instruction was not objected to. They did instruct that the porch is part of the house, so I believed myself to be in the same situation as Richardson, and I did not raise that separately.
I mean, Riddle said, where a person is in his castle, which includes the curtilage, there is simply no safer place to which to retreat. I mean, was there a significant question here that the jury may have thought that he had an obligation to retreat?
In terms of prejudice, Your Honor,
And concomitantly, an obligation to avoid confrontation. That was what the focus of the prosecutor was in his closing statement, that somehow he invited this, he engaged in a confrontation, he rushed outside the home when the knocking continued and the person appeared to be on the verge of banging in the screen or something to that effect. That was not the moment if that had been the exclusive moment in time upon which the jury had focused, it should have understood, had it been apprised more clearly, that he had no obligation to cower in the corner, no obligation to avoid conflict, no obligation to do anything than to exercise what he thought would be a reasonable effort in self-defense.
I agree with you on all those things, Your Honor.
There was an
I
argument.
believe you can take that into consideration in the prejudice prong here, that those arguments were wrongfully made by the prosecutor. The Court of Appeals found that in my proximus conduct issue, and that can be considered in terms of a cumulative prejudice here.
But in terms of, a straight-up objection, it wasn't objected to below. So you would be on plain error.
They did not ask that the no retreat be not mentioned at all, no. But the court could consider it.
Do we know, can I ask one, are you out of time? I'm sorry. Well, I'll ask anyway. In terms of the factual record here, a lot is made of the kicking, that it was believed that she was trying to kick down the door. Do we have any idea where there was kicking? So, like, if you're kicking down low, you might just be trying to make noise. If you're, like, up and doing some acrobatic move, you might be trying to kick down the door.
As I stand here, Your Honor, I don't remember where the smudge marks and the imprint of the screen on the inner door, I don't remember where they were in height. I apologize.
Thank you.
Actually, Counsel, I just want to make sure, because I have a few questions. I just want to see if anyone else has their questions. So I just want to, Counsel, I have been thinking intensely about this case, and I want to actually apply this to a real-life situation, and I want you to kind of walk through this with me, because I think it's directly relevant to the case here. Just very, very quickly, it was the Jewish holidays, and I was doing a speaking event in California for a synagogue, and the way it works in Jewish communities is that when it's Shabbat, people aren't allowed to do work, which means that you can't use doorbells and things of that sort. So it was after we had finished at the synagogue, after the event concluded, that we were going to go to one of the congregants' homes to have lunch. And this was a wonderful area within Los Angeles, and basically the homes in this area are very, very large homes. So the way it works is if people are coming over to visit and they can't use the doorbell, it's custom, because the homes are so large, that people go into the back, where they'll be on the patio or the terrace, or in those areas of the home where they're going to kind of do the entertaining. And ironically, what happened was that we had the address and we were going to the house, and what had occurred was that there was a north and a south on the same street. So we went, same address, but north and south. So we went to the southern address, and ultimately the custom is, again, the door is closed, right? The doors are left closed, but they're not locked. So, the way my life always works, we walked into the home, walked into the house. And because it's a large house, in order to get to where the festivities were, we were walking well into the house. And of course, we were in the wrong house. And the only good thing about this was that the homeowners were, the thing that was happy to me was they were not upset that we were in their house. They were disappointed that we couldn't stay for lunch, because they actually were at the synagogue that I had spoken at. But the point of it is that going through the analogy that I just gave to you, at what point in that process, where basically I had, with the folks I was with, entered the property, walked up, opened the door, walked into the home, and proceeded through the home. Now, I'm not saying people should do this. I'm just saying this is what happened. At what point in that process, if we take it back to your case, would the defendant be entitled to the presumption and the jury instruction?
When you entered the home, or when you were, let's say they heard you entering the home, they heard you jiggling the door and coming in. Now, it's going to be a jury question. I mean, there's factual differences that are important. It's not the middle of the night. It's not, violent banging. I think that the jury would have trouble finding that is proper to shoot someone at that point. But again, that is a jury question, and it is not near the circumstances we had here.
But in order to understand this, is it I'm just trying to understand at what exact point would the instruction be given? Would it be given when I open the door, when I open the screen, when I walked in, when I'm in the front part of the house, when I'm in the back part of the house? Like, at what exact point would that presumption then kick in upon my entrance into that home?
Your Honor, if you look at the breaking and entering statute that still exists, the felony one is now subsumed in home invasion, but we still have the misdemeanor one at 750.115. Under that statute, breaking and entering is completed when you enter, and in the process of would be as you are trying to enter. Again, if you look at if you look at the exemptions in this statute, which none of us discussed because they weren't relevant to our case, the legislature does create some exemptions, but they're also very specific. If you had a child inside that house and were going to retrieve your child, then the presumption wouldn't be allowed. If you were a police officer executing a search warrant, the presumption wouldn't be allowed. But outside these specific exemptions, we are stuck with the language in the process of breaking and entering, which is very broad, and it becomes a jury question.
So, okay, and I think I understand your argument. I just want to make sure I understand it. So the presumption kicks in the minute that the minute the door opens, the minute you. That's what I'm trying to understand is exactly at what point
the homeowner understands you to be, or you are in the process of breaking and entering, which, as I've indicated, is broader than attempt. So it doesn't require a completion. You are at the door and trying to get inside.
So if you open the door, I'm just
So
trying
yes,
to,
definitely if you've opened the door.
Okay, so like I say, and again, I'm using this example because this was a more religious neighborhood, so it's custom that people walk in. That's just kind of how it is.
Now, those things are going to go to the jury
Right, I
question of
understand.
whether it's an honest and reasonable belief that since it's broad daylight, there's a holiday going on where this is the custom, that, whether or not the jury would accept that defense, but it would entitle the defendant to the instruction on the defense.
But let me ask you a question, though. Would that defense then, and I'm just trying to really understand your argument. So would that jury instruction then be applicable to a delivery person? So, for example, a lot of times, like if FedEx is coming, you're going to tell FedEx, please, I'm going to sign the waiver that says, please don't take it back to the post office. I don't want to go to the post office. Can you please just leave it in the door? So if UPS or FedEx or the United States Postal Service is coming and you tell them specifically, please leave it in the door, is it the minute that the screen opens? Is it the minute the door opens? Is it the minute, is the postman or the delivery person, if the door is open, if they open the door and say, hello, it's UPS, is that, that's what I'm trying to understand. Like, what do I use to gauge this?
More clear than I have been until now, Your Honor. I am not saying, and I don't think the law supports, that you can shoot someone who's knocking on your door in the regular course of business during the daytime. I think I put a footnote in that talks about the cases that I've dealt with, search and seizure, and they talk about, we're used to the newspaper delivery man, we're used to the Girl Scout, we're used to FedEx coming to the door. So hearing a knock or hearing it open and something slipped inside in the middle of the day is not going to lead to the conclusion that someone is breaking and entering.
I understand.
But turn that around and make it nighttime and violent banging.
But I'm just trying to understand the red line. I'm trying to understand I'm just trying to understand when the statute can be, when the instruction can be given. Is it based on the time of day? Is it based on what the person is doing, or is it based on when they approach? I'm just trying to understand.
I'd say it's a totality of the circumstances, Your Honor.
So it's a totality then. It isn't then based on the specific of opening a door or opening a screen. What you're indicating is that it's based off of the overall situation then. So you would look at
I'm sorry.
No, please go on.
You would look at the totality of the circumstances and decide whether there's some evidence that would require the instruction to be given. Now, it's a different question as to whether the instruction should be given and whether it is going to succeed.
Right.
But again, during the normal business hours, somebody knocking on your door in a normal manner is not going to entitle someone to the instruction because there's no evidence they were in the process of breaking and entering.
Well, lest the record suggest to anybody that we're talking about a Federal Express man coming to the door at 5 o'clock in the afternoon, we're talking about somebody at 4 o'clock in the morning banging at the side of your front door in a high-crime neighborhood after you've been subject to a series of episodes and numerous episodes of crime, banging at the side door at that time of day, moving to the front door, banging at that time of day, apparently kicking in a screen in part, apparently breaking a peephole on the front door, apparently damaging the screen door and moving it out of place, and then suddenly rushing to the home when the occupant of that home, as he was fully entitled to do, opened up the door at 4 o'clock in the morning to see what was going on while armed and rushed at that individual. That's not exactly the same as the Federal Express carrier. This is sufficient based on your assessment of the totality of circumstances to suggest that this satisfies the statute in suggesting that there was a breaking and entering that had either occurred or was in the process, and B, that the occupant of the home had a reasonable belief that there was such a breaking and entering or someone engaged in the process of doing that. Would that be a fair statement?
Absolutely, Your Honor. All fact-intensive questions, all hypos are, and jury questions that we ask juries to make all the time. Thank you.
Thank you.
May it please the Court, Tim Boffman, Assistant Prosecuting Attorney, representing Kim Worthy, the Wayne County Prosecutor, and the people of the state of Michigan, who are the appellees in this case. Counsel wishes to give to statutory presumptions a purpose and effect that they have in no other situation regarding statutory presumption, and inconsistent with clear statements by this Court in the Wiedmeyer versus Leonard case. If in this case sufficient evidence had been presented to support a finding that the Renisha McBride was in the process of breaking and entering at the time that she was shot, that would have been equivalent under the law of presumptions. There's a statutory presumption. If there were sufficient facts of that, that would have been equivalent in the law, as Thayer and Wigmore point out. That is equivalent then to fact A becomes equivalent conditionally to fact B, that you have an honest and reasonable belief of imminent fear of death or great bodily harm. But it's conditional, and if it casts then upon the burden of the opposing party, and here we have a burden shift in affirmative defense in a criminal case, so the prosecution, when the burden shifts, has the burden of persuasion beyond a reasonable doubt. But it shifts that burden, and two things are going to happen then. Either the prosecution is not going to meet it and the defendant gets a directed verdict, or the prosecutor is going to meet it and the presumption disappears. And what is left is whatever inferences can be drawn from all of the circumstances that the defendant argues shows a reasonable doubt, and the prosecution argues doesn't show a reasonable doubt under instructions on self-defense, which is exactly what happened in this case. The defendant got instructions on self-defense, the ones that he requested, that they were given. The prosecutor argued that there was no reasonable doubt in the case. The defendant argued there was, and the jury convicted. The presumption functioned exactly as it should have, and there should not be an instruction on it ever.
So I think that, this might answer some of the questions I was having, trying to figure out how, if you got both of these instructions, you would know what to do with them. I can't figure out what, if a jury heard the first one and it says you must presume basically that self-defense, it's basically telling a jury it's directing a verdict.
Exactly. That was going to be my point. The instruction as it currently exists is a hair.
I know your yellow light's still on, by the way, but I think you can take it.
Pardon?
I know your yellow light's still on, but I think you can take it. So
it's that close to a directed verdict. The current instruction is that it says nothing about the rebuttability of the instruction.
It doesn't say it's rebuttable.
It simply says, so the prosecutor rebuts it, and nobody has ever argued there's insufficient evidence in this case for the jury verdict. It's never been said that, well, there's insufficient evidence to find beyond a reasonable doubt that he wasn't acting in self-defense. That's not an issue. So the prosecutor rebuts it, and the jury's still told that they must find. It doesn't make any sense.
It doesn't make any sense.
It doesn't put only a thumb on the scale. It puts a whole hand.
I think it tells them what the answer is. If you get this instruction, I don't know how you get to consider anything else.
And my point is, again, if you look to Wiedmeyer, the function of a presumption is solely to place the burden of producing evidence on the opposing party. And this court also said there, while the presumption may be overcome by evidence, we presented evidence from which a jury could find beyond a reasonable doubt he didn't act in self-defense. The inference remains and may provide evidence sufficient to persuade the trier of fact to raise a reasonable doubt here. But always it is the inference and not the presumption that is weighed against the rebutting evidence. So the defendant argues his inferences that remain after the prosecution has presented rebuttal evidence to overcome it sufficiently. Here, proof beyond a reasonable doubt that at least that a reasonable fact finder could find beyond a reasonable doubt. That
Are you looking at Michigan rule of evidence?
There's no presumption at all.
Are you looking at rule of evidence 301 or 302?
Yeah, they are not applicable. There is no rule in Michigan that deals with this situation.
That's right. The civil rule is not any more applicable than 302.
No, this is a highly unusual situation, as I said in my brief. There is no other case, another situation that I can find of where there's a statutory presumption in favor of the defendant in a criminal case. So this court has to determine what do you do in that situation, and I don't see any reason why you don't apply the ordinary rules that apply when there's a statutory presumption. The defendant, if he meets it, now we've argued he hasn't met it, the Court of Appeals said he hadn't met it, but the instruction was given anyway. If he meets it, the prosecutor has to rebut. It shifts the burden. Here it shifts it beyond a reasonable doubt. The prosecutor assumed that burden. The jury was instructed on that burden, and then the jury convicted. The jury should not be instructed, certainly on the presumption as it's written now, because it says nothing about rebuttability, but it really shouldn't be ever instructed. You either rebut it, you either present sufficient evidence from which a reasonable fact finder could find beyond a reasonable doubt the defendant didn't act in self-defense, and the presumption disappears and people argue their inferences, or you don't, then there's a directed verdict. But there's no instruction.
So that's how it should operate? Is, in your view, this, I mean, I don't know. I don't know when this jury instruction was drafted, and I agree with you because it doesn't say it's rebuttable. I feel like something's missing if it is to be a jury instruction. But how do you think this should work? There is the statute where the legislature obviously wanted some heightened protection for people in their own home who have to deal with this situation. How can we give effect to what the legislature wanted to do in a way that makes sense?
I think we give effect the way we do every other statutory presumption. If the defendant meets the factual predicate, he need present no other evidence of any sort that he was in honest and reasonable fear of death or great bodily harm. That does it. That substitutes for it. And then the prosecutor... So then the judge just directs a verdict, or that puts on the prosecutor the burden of rebutting that he wasn't. But when the prosecutor does so, then it's a matter of proof to the jury, whatever inferences remain, but there's no presumption.
So then it shouldn't be a jury instruction at all?
No, it shouldn't be.
It should never have turned into a jury instruction. Where were you when it was made into a jury instruction? I thought you were in charge of
Well, we corrected it once, but some things need to be resolved by litigation. The committees can't really resolve them. But let me give a quick example. There's one statute, I believe, that, for example, that says if you own a watercraft and it's in an accident, if it was used by a member of your immediate family, it is presumed rebuttably that you gave consent. Now, I'm the owner, my son uses it, there's an accident, there's a presumption in the case that I gave consent. I get on stand and say, I didn't give consent. Under the law, the presumption is now going to disappear. The defense is free to argue, yeah, come on, he gave consent. Look at it, it's a member of the immediate family, and I'm free to argue, no, I didn't give consent. There's no instruction given on the presumption. It disappeared when you gave contrary evidence. That's exactly what Widmeyer says. The presumption is there. I mean, the function of a presumption is solely to place the burden of producing evidence on the opposing party. That's what this court said. It did here, and we met our burden. The jury found him guilty.
Well, in a civil case, the reference to rebuttable presumption makes sense, and one needs only to look to MRA 301 in order to determine the effect of that particular presumption. But in a criminal case, as you yourself acknowledged, there are no obvious principles that govern these kinds of rebuttable presumptions in favor of the accused. I understand they're unusual. In fact, this is the only one of which I'm aware. But it's different, it seems to me. I wonder, let me just ask you a question. Why shouldn't the court, when it gets this kind of presumption in the context of a criminal case, not have to simply consider the relationship between the common law and the statutory scheme to determine the effect of that presumption? And in this case, at least, arguably, it suggests that the prosecutor has some, perhaps uncertain, but some additional legislatively imposed burden at trial. We can debate and discuss that, but it doesn't mean nothing.
Well, it doesn't mean nothing. It means that without any other proof, of being the honest and reasonable fear of death or great bodily harm, and we're talking about lots of situations other than this one, without any other proof, you've shifted the burden of proof to the prosecutor. And it's different than the civil presumption, because remember, the civil presumption says the burden of persuasion never shifts, and it does here. So there is an additional burden on the prosecution under this rebuttable presumption. We take the burden of proof beyond a reasonable doubt. We have the burden of persuasion, and that doesn't happen with the civil presumption. So there is a difference. And if the legislature wished to do something other than have rebuttable presumption that works in the way all rebuttable presumptions do, I think it needed to say something other than what it said. What it said was, and it is taken to understand what the law is in the state, what it said was use terminology that is used in statutes all over the place. Now, again, you're correct, it did not use it it's never been used before in a criminal case. And as I have in my brief, the few jurisdictions that have considered this sort of presumption have applied the civil understanding of how presumptions work in this situation. Some of them actually have rules that deal with it, as Rule 303. But they have said that we're going to treat it exactly like Rule 301, except that they're not entirely accurate because the burden is shifted, the burden of persuasion is shifted.
Mr. Boffman, don't you think the architects of this presumption at least would have liked to have communicated through this presumption that somebody in the circumstances of defendant in this case was entitled to be full of piss and vinegar in reacting to the circumstances he confronted at 4 o'clock in the morning? During your closing argument, the prosecutor argued that this was somehow something characteristic of Mr. Wafer that ought to be considered somehow a negative against him. Later, he wanted a confrontation, according to the Wayne County prosecutor. Wouldn't the presumption at least have communicated that, although I think it's an extraordinary thing to say he wanted the presumption that was forced upon him, but he was entitled to engage in that presumption with as much force as necessary because he feared for his life, and he feared the only way that he could protect it was by engaging in the kind of defense he was in the process of engaging in?
I think that's a good jury argument, but I don't think if the legislature wishes to put a powerful thumb on the scale to the ordinary law of self-defense, that it has done so with this statute. And I don't believe that this statute, society or this statute, is in the position that a person, when their door is being pounded on at 4:30 in the morning, even if they're at least objectively afraid, or even objectively, that if that person opens their locked steel door and shoots the first thing they see, that a jury can't find that they did not have an honest and reasonable belief at the time of the shooting.
The first thing he saw was somebody lunging at him. The first thing he saw was someone lunging at him. There was that intervening circumstance.
The defendant was asked, what is it about Renisha McBride that made you so afraid when she was on the porch? This was violent. There was violent bangings. I never heard anything like this. He said nothing about her attacking him. There was no claim that, gee, I was afraid she was going to jump on me. He was asked if he saw anything in her hands, and he said no. These are all things that go to the jury under instructions on self-defense without thumbs on the scale, because the prosecution has presented in this circumstance evidence from which a jury could find at the time the defendant shot he was not in imminent fear of death or great bodily harm, reasonable and honest. They could find it was not reasonable. Again, and you can see why society would wish this. He could have been a neighbor that was coming to tell him, hey, there was somebody not pounding on your door and I chased him off. He said he didn't know the gender, he didn't know the race. He opened the door and he shot. And he said he did it intentionally. He told the police it was accidentally. He told the jury he did it intentionally. And the jury determined under instructions on self-defense that he didn't have an honest and reasonable belief at the time that he shot and killed this unarmed woman who was on his porch.
And you don't think that that environment that the jury was working within would have been affected by the presumption? I understand what you said about the presumption, but you don't think that would have redefined the environment?
A jury certainly might be affected if you put thumbs on the scale. I don't think the statute does that.
Would the jury have also been affected here if the instruction had made clear there was no duty to retreat, as has been the law in Michigan for well over a century?
Well, Your Honor is raising an issue that's never been litigated in this case, and I believe the jury was instructed there was no duty to retreat. The defense asked for it, and it was given, and they were also instructed that the porch was part of the dwelling. So I think if you looked at that instruction in its entirety, there's no way it would be found to be plain error. I don't think it's error of any sort.
Explicitly that the jury could consider retreat as a factor. What is the context within which that's...
In the context, it's like saying you can consider retreat, and here's how you can consider it. It's no factor. The defendant didn't have to retreat, and the porch is part of that. I think that's the context of what the jury was told, and to which the defense was happy with. They wanted it, they got it. And I don't think it's an issue in this case.
Well, I don't want to ask a cheap question, and I won't, but what exactly should a person do who's confronted with this kind of situation at 4 o'clock in the morning in parts of Wayne County in which life is a little tougher and a little more precarious than it might be in the places that most of us live in?
You can either call the police.
You can call the police.
Yes.
Okay. Well, he didn't have his cell phone with him.
Well,
he didn't have a smartphone in his side.
You can wait with your loaded shotgun and see if somebody does come through the door, or you can open the door.
He doesn't have to wait. The home, his curtilage, his castle, the area in which he has an entitlement to protect himself extends outside the door, beyond the door.
Your Honor asked what might he do. He might wait inside with the shotgun.
He doesn't have to do that.
I didn't say he had to do that. You asked what might he do. He might do that, or he might open the door with the shotgun and confront who's ever there and find out what they're doing. But his first activity to a person who has made no threat by word or gesture to him is not to blow him away. In my opinion, I don't think the statute says that. And the statute, what we're here for is, does the statute put, as counsel said, a thumb on the scale in jury deliberations? I think it does not. And this current standard jury instruction is wrong in any event, because it almost directs a verdict if that is given. It does more than put a thumb on the scale. But again, our position is there is no thumb that is ever put on the scale. This presumption is treated like any other presumption, except it shifts the burden of persuasion beyond a reasonable doubt to the prosecution. Thank you very much.
Actually, I have a question. Because I'm still confused. I'm trying to understand. I like to try to keep things simple, and I'm really just trying to understand. At what point, I'm just going to give you a quick, this is not real, this is just a complete hypothetical, but I'm trying just to grasp this. Hypothetically, let's just say, as a blind person, I'm not aware of my surroundings, I don't know what's going on. Let's say hypothetically I'm in my home, and I hear, someone kind of coming into, or I hear certain noises, I hear, banging, whatever it is. I'm just giving a complete hypothetical. What I'm trying to understand, which is why I asked this to your counsel, is I'm trying to understand at what point do I get the rebuttable presumption? At what point do I have to wait for the person to come in? Do they have to, what is in terms of like trying to move forward with this presumption and trying to understand how this is applicable, can you give me an answer as to at what point would I be entitled to the presumption if I'm in my home and something is happening, or I'm scared, or there's rattling, or someone's coming in, but I'm not certain? When do I get this rebuttable presumption? If I'm in my home, I'm uncertain of what's going on, I don't have a sense of awareness because of my disability, but I'm genuinely concerned or afraid. I don't know exactly the circumstances of what's happening. What I'm trying to understand to you, at what point do I get the presumption?
Well, let me say this first. This defendant did get the presumption because the burden shifted.
No, we're talking about the
specific
jury instruction.
The burden shifted to the prosecutor. So
right.
And this court may have to decide this question. You get it when the person is determined to be in the process of breaking and entering your home.
When is that?
What does in the process mean?
Right. Because here's the thing. What I'm trying to understand from you is, when is that? I'm here. I'm blind. I don't know what's going on. I guess what is that? Tell me that. You have to give me an answer as to what you think the process. Give me a specific example or answer as to what that entails.
Well, if Vernicia McBride had knocked the steel door off the hinges,
she had to knock it off the hinges, or did she attempt?
Even if she hadn't come in, if he knocked it off, then I think a person inside because you could say the presumption exists. Now that still means that what it does is you don't get an instruction on it. It means the prosecutor has to prove beyond a reasonable doubt that you were not in reasonable fear imminently of death or great bodily harm. The presumption is who has burdens, not instructions. If we take your other example, Your Honor, where you went into the house by mistake
Yes.
and you went in there,
And I was in the house.
That would raise the presumption.
Okay.
But let's assume that the person inside.
So you would concede that when I was in Beverly Hills and went into that house.
You're lucky to be alive.
Yes.
No, and again, I'm not trying to like, give you a hard time. I'm just trying to understand.
I understand.
What the specifics of the argument are. So when I went into that house, the presumption, that homeowner had the presumption at that point. Because I'm in the house.
And that means the prosecutor has to rebut that presumption with evidence that would prove that the person was not in imminent fear of death or great bodily harm beyond a reasonable doubt. So let's assume the evidence shows that the person knew who you were and knew you were unarmed and shot you anyway. You wouldn't get an instruction on the presumption. The burden would have shifted to the prosecution. The jury would be instructed as it wasn't here, and it would make a decision. If I could give a quick other example. My time's up.
No, I want to go. I'm trying to get an answer. I'm trying to
understand. The case pending in Washington State right now, this presumption applies also to business places. Somebody breaks into a business place and is present there when they're encountered. Guy has a house, and he has another house next to it that is his business. He notices the business appears to have been broken into. He goes inside, and there's a guy in the shower. This case is actually pending in Washington State. He goes back and gets his gun, comes in and shoots him 3 times in the shower and kills him. Does he get an instruction on the presumption? No. If he gets anything, in that case, I think he gets no instruction on reasonable doubt. But if you say the presumption triggered on the prosecutor the burden of proof beyond a reasonable doubt of self-defense, then you instruct on self-defense and you argue the inferences. But he gets no instruction on the presumption ever, in my opinion.
But I'm still don't have an answer. I still am confused. In terms of the hypothetical that I just gave you, is there no clear anscer then as to exactly when the rebuttable presumption is entitled or not?
Unless
I'm just trying to understand at what point. This is just what I'm trying to. And again, I'm not trying to give you a hard time. I'm just trying to understand. I'm trying to exactly at when is the point? When is the threshold that the rebuttable presumption is given to me, the blind person in my house, who is fearful or doesn't know what's happening.
Well,
I'm trying to understand at what point do they have to open the door? Do they have to try to come in the door? Do they have to be on the porch? Do they have to be speaking? Do they have to be the most scary thing for a blind person if they're not saying anything? It's so subjective that I'm trying to gather from you exactly when does that rebuttable presumption kick in?
I can't give you an answer to exactly when it applies because what the statute uses is the language in the process of, and that's case specific, I think. I can't say. We've argued in the Court of Appeals held that the facts in this case aren't sufficient, but my argument is it really doesn't make any difference because
it's a case by case?
He got the instruction anyway. He got the burden shifted.
So is this a case by case, or is there any kind of black letter that we can adhere to?
I can't give you a black letter.
So there is no black letter. You're saying this is subjective and it's a case by case analysis.
I can't give you a black letter.
When the instruction should be given?
Well, the instruction should never be given. This issue would be really live if, in a case, a judge determined that the presumption wasn't raised, there was no other evidence of fear of death or great bodily harm, and refused to instruct on self-defense. Then the issue would be live. Here, since the jury was instructed on self-defense, which is what defendant would get if he met the foundational facts for the presumption, that issue isn't really presented.
Okay, thank you.
Okay, thank you very much.
Thank you. Thank you. I think your time is up, is it not? Is there time left here? Sorry, thank you.